I'm going to talk today about defending allegations of driving with excess alcohol. The legislation is contained in two acts from 1988, the Road Traffic Act of 1988 and the Road Traffic Offenders Act of 1988. Those pieces of legislation set out the circumstances under which an individual may be prosecuted if they're found to have been driving or in control of the vehicle over the legal limit. In England and Wales, as I've said in the previous video, the legal limit is 35 micrograms of alcohol in 100 millilitres of breath. The reality is that the police do not prosecute where the limit or where the breath reading rather is less than 40 micrograms of alcohol in 100 millilitres of breath. Between 40 and 50 micrograms of alcohol in 100 millilitres of breath, the police will offer a blood test to be taken, blood sample to be taken, and the reason for this is that a blood sample is more accurate than a breath sample. I want to talk about Section 7 of the Road Traffic Act 1988 because that sets out circumstances in which the police may also take a blood sample for other reasons. I've got my laptop here. I'm going to have to look down at the laptop because I'm quoting directly from the legislation. So there are three circumstances in which a police constable may also decide that it's necessary to have an individual provide a blood sample. So the circumstances are these. It may be, for medical reasons, a specimen of breath cannot be provided or should not be required. I don't propose to go into all of the medical reasons that could be applied, but for example, if an individual had a genuine phobia of needles, genuinely couldn't have blood taken out of their arm, that might be a genuine medical reason. Of course, it would depend on the circumstances. The second reason is this, and again I'm going to have to look down to quote directly from the legislation. It may be that at the time the requirement is made, a device or a reliable device of the type mentioned is not available at the police station, or it is, then for any other reason, not practical to use such a device. And that really is a catch-all term. So if it's simply not practical for whatever reason, for example, there may be too many people at the police station at the time or needing to be breathalyzed on the machine, it may be practically not possible to put everybody through. There may be X number of reasons why that is the case. The third reason is this, again, excuse me, I'm going to have to look down at my laptop just to quote directly from the legislation. And that is that the constable who required the specimens of breath has reasonable cause to believe that the device has not produced a reliable indication of the proportion of alcohol in the breath of the person concerned. That's really interesting because what that means is if the constable has conducted the intoxilizer breath test, if the individual has provided 2 samples of breath, if those samples of breath are, in the officer's opinion, too low, if they don't reflect how intoxicated the individual is, then the officer can reasonably require that a blood sample also be taken. So, for example, if the machine hasn't been calibrated correctly, if the machine is not working, any of those problems, if the officer considers that the suspect is over the limit, then if the intoxilizer machine is saying otherwise, then it may be that the officer can still, provided that the belief is reasonably held, then the officer can still require a blood test to be taken. Of course, all this is after what would normally be a roadside breath test failure. So if an individual passes the roadside breath test, the matter goes no further. If the individual fails the roadside breath test, they will generally be arrested, they will generally be taken to the police station, there will usually be a custody suite, and there will usually be an intoxilizer machine present. The legislation says that the individual gives 2 breath readings, and the lower reading is the reading that is accepted for the purposes of any prosecution. However, as we've just considered in section 7, even if the intoxilizer gives a reading that is not over the legal limit, but if the officer thinks the machine is not giving a correct reading, then the legislation exists under section 7 of the Road Traffic Act to allow the officer still to ask or insist on a blood test. Now, if a blood test is given, if a blood sample is taken, then the suspect should be provided with a sample to take away with them for them to have the test conducted themselves if they so wish. And the reason for that is also quite important. A blood file should be kept in a fridge in cold conditions, the same temperature. If an individual is putting numerous blood samples in a fridge and opens the door each time, then that could affect the temperature. Equally, the blood file should be shaken up so that there's a consistent amount of blood throughout the file for testing. It may be necessary to include preservatives within the blood in order to prevent it congealing, or indeed to prevent it fermenting and the alcohol in the blood actually increasing in its potency. For all those reasons, if an individual is provided with a blood sample, they may be wise to consider getting the sample tested as quickly as possible in order, if there is any discrepancy between the results in their sample and the sample that is presented as evidence in court, it may be possible to argue that the differences are due, for example, to the sample that the police have held not being stored correctly. All of those could potentially provide ways of successfully defending an allegation of driving with excess alcohol.